Hi, my name's Alex. I'm an attorney at Texas Rio Grande Legal Aid, TRALA. The purpose of this video is to provide you with legal information. It's not legal advice. So for legal advice, you should make sure that you consult directly with an attorney. So this video is going to be about the legal process when you fall behind on your rent and the landlord is threatening to remove you from your home. If you can't afford to pay the rent, we always recommend that you just speak to your landlord directly and you try to work things out directly with them first. Sometimes you're able to reach a resolution without going through the court process. So you have to think about your goals. Do you want to stay in the home permanently? Do you want to just stay in the home as long as possible, or do you want to move out immediately and just get out of the situation? So if you decide that you're going to move, you have to make sure you're released from the rest of your lease legally, and that any agreement you reach with your landlord is in writing. The agreement has to be signed by both you and your landlord to make sure that you're covered. So if you stay at the home and you're not able to reach a payment agreement with the landlord, you still have the opportunity to go through the eviction process. Your landlord has to go through the eviction process to remove you from your home, and the eviction process can take several days or even weeks. And we'll discuss the time frame a little bit more later on in this video. If you can't reach an agreement with your landlord, the landlord still has to follow the legal eviction process. I am going to be using a calendar as a guide in this video. The calendar can be helpful because there are several dates involved, and it can be very important to understand the deadlines at each part of the case. So this calendar is just an example because in each case the dates are going to be different, but hopefully it just helps understand the basic process and the time frame that you'll be looking at. The first thing you always have to ask yourself is, have you received anything in writing? If the answer is no, if you've only received a text message or a call, this is not enough. It has to be in writing, a piece of paper, a written notice to vacate. The landlord is going to have to go through a process after giving you that notice in order to legally evict you and to force you out of your home. They can't just call the police and have the police remove you. They can't change the locks permanently. They can't cut off the utilities like water, electricity, gas. The first thing they have to do is just give you a notice to vacate in writing on paper. It has to give you at least 3 days to move out, or 1 day if the lease allows it. So you always have to look at your lease to make sure, but typically, unless your lease allows 1 day, they have to give you at least 3 days in the written notice, which is the first step. So at this point, we're going to go to the calendar. And again, this is just an example, but in this example, your rent is due on June 1st, and you're not able to pay the rent at that point. And so as early as June 2nd, the landlord can give you a written notice to vacate. That would give you until at least June 5th to move out, depending on what the notice says. If you have not moved out by June 5th, the landlord still has to sue you in justice court. They still have to go through the complete eviction process that we're going to explain later in this video. The court's going to notify you of the lawsuit either in person, or if they can't find you, then they might notify you by mail. They'll give you the actual petition that the landlord filed, and it'll just have an explanation of what the case is, when your hearing date is, and in this example on the calendar, you can see that you're served on June 15th by the constable. But again, that could sometimes be in regular mail if the constable can't locate you. So the paperwork you've received, it's sometimes called a complaint. It's going to have the address of the courthouse where you need to appear. It's going to have the date and the time of the hearing. The hearing's typically going to be 6 to 10 days from the date you're served, the date you received the lawsuit. These days can be a little bit different now because of the COVID-19 pandemic. but typically 6 to 10 days in the paperwork, the complaint will notify you of when the hearing date is. So in this example, the hearing is on June 22nd, the Justice of the Peace, which is where the first eviction hearing is going to be held. You want to make sure, of course, that you go to the hearing. You want to arrive early because you never know if you might have difficulty parking or run into other obstacles along the way, and you do not want to miss the hearing and have a judgment ordered against you without you being able to explain your case to the judge. So you want to bring your receipts and your rental agreement, any other evidence that you have about the case, anything you want to explain to the judge about the situation, bring it with you to court so that you can show it to the judge. If the landlord doesn't appear, then you should ask the court to just dismiss the case. If the landlord does appear, you still have the opportunity to discuss whether the eviction notice you received was correct. Again, you have to receive that written notice to vacate before they file the lawsuit. Or if you disagree with the amount that the landlord is asking for, or if you have other issues that you want the court to be aware of, you can bring all of those things up at the hearing. So if you lose, you're going to get a paper copy of the judgment. That's going to show how much the judge ordered that you owe, that you were behind on rent, or that anything that you owe the landlord. So if you're not giving the judgment automatically, just make sure that you ask a copy, because it does have important information about your rights and about what exactly the judge ordered. You're going to have 5 days from the date of the judgment, the date of your court date, typically, to appeal or move out. You want to make sure that if you don't move within the 5 days and you need more time to move, then you can file the appeal in a specific way with an affidavit that says you cannot pay the cost of the appeal. And we're going to explain this a little bit more now, and how to fill out the form later. But it's just a basic form that says it includes your financial information, and it says you can't afford to pay the cost of the appeal. There are other ways to appeal an eviction judgment with a bond or a cash deposit, but we're not going to be discussing those ways in this video. So if you do have a place to move and you don't need more time, you should just be aware that you might be responsible for the landlord's attorney's fees if the landlord hires an attorney. So you really need to think about why you're appealing the case and the reasons why you want to pursue the case, just because of that possibility. If you need more time to move, you should appeal on the last day. We're going to explain this a little bit more later, but it just gets you a little bit more time to move sometimes when you wait until the final day to appeal. And so we mentioned that you have 5 days from the judgment to file your appeal. When you count these days, you're going to count every day, including weekends and holidays. But if the 5th day happens to come on a weekend or a holiday, then you have until the following day that's not a weekend or holiday. So if it falls on a Saturday, then you would have until the following Monday, as long as the Monday is not a holiday. One other thing to just keep in mind, some courts do close before 5 p.m. So if the court closes before 5 p.m., you do have until the next day to appeal, even if you just have one extra day if the court happens to close before 5 p.m. So back to the calendar. In this example, your hearing was on June 22nd. And so the 5th day after your hearing was on Saturday, June 27th. And so because it was a Saturday, it just goes to the next weekday or date, as long as it's not a holiday. So here your deadline to file your appeal is going to be June 29th. You have to make sure that you make time on the final day on the deadline to file the appeal. You want to go as early as possible, because you don't know, what obstacles might get in the way, or if you have questions about the paperwork, or you have to talk to the clerk about something. There's just a variety of things that can come up, so you want to make sure you do it very early in the day, because it's an important deadline not to miss, and you just don't know what's going to come up. You're going to go back to the same court where the hearing was held, and you're going to file the appeal at that court of the justice of the peace. If you don't file the appeal, the landlord can ask for an order. It's called a writ of possession, but it's an order where they ask the constable or the sheriff to remove you from the residence. Once the court issues the order, the constable or the sheriff will give you a 24-hour notice. It'll be posted on your door and it'll tell you that you have to move out within 24 hours. If you don't leave in that 24 hours, the constable or the sheriff can remove you in all of your things. So just be aware if a judgment's been ordered against you and your appeal time frame is running out. You just have to be prepared to leave within a 24 hours notice after you receive the notice from the constable. So one thing you can do if a judgment's been ordered against you and you appeal, time frame has run out and the court orders this sort of writ of possession and you've received it from the constable, you can then call the office of the constable and the sheriff. Sometimes they might tell you when they actually intend to forcibly remove you from your home. But in general, you do want to be prepared to move within the 24 hours after you receive it. If you file the appeal on time with an affidavit saying that you can't afford the cost of the appeal, which is the one that we're going to show you, and you're being evicted for non-payment of rent, you have 5 days from the date that you file the appeal to pay 1 month's rent to the justice court. If you're unable to pay the 1 month's rent within 5 days, the landlord can get a writ of possession, the 24-hour notice. So here, we're going to go back to the calendar, and you filed the appeal on June 29th. And so you have 5 days from that date because you used the statement of inability to pay 1 month's rent to the court registry. But because it falls on a Saturday, a weekend, it gives you to the following Monday. And so if you have questions about court holidays or their schedule, you can always call them to let them know. If Monday had been a holiday in this example, then it would just go to the next Tuesday. As long as you file your appeal on time, then the case is going to be sent to county court. You will eventually receive a notice of a hearing date. You are required to file a written answer within 8 days of the case going to county court. So it is a good idea to just file one with your appeal in justice court and to take care of that at the same time that you're filing the appeal. So the form we're going to show you shortly does include an answer automatically. And so when you file your appeal and your statement saying you can't afford the court costs, it'll also include an answer, and the justice court will forward that answer to the county court, and then that'll be taken care of and you don't have to do it again. If you ask the court for their form appeal in the statement that says you can't afford the court costs, that does not always include an answer. So just make sure if you don't use our form that you do try to file a written answer with your appeal as soon as possible. If you want to stay in your home until your county court hearing, then there's another obligation to pay rent each month to the county court registry within 5 days of when it's due. The rent is due under the lease. So here, if we file the appeal, so for example, if you file the appeal in June and you pay to the court registry within 5 days to perfect your appeal and have it sent to county court, your appeal will be heard no matter what. But if you do want to actually stay in the home until your county court hearing, then in July, or the following month after it's sent to county court, you'll have to start paying rent to the county court registry within 5 days if it's when it's due under the lease. So if your rent is due on the 1st of the month, you're going to have to pay by the 6th of every month until your case is heard in county court. And again, that's only if you want to stay in your home while the appeal is pending. As long as you file the appeal and do the initial payment 5 days afterwards, then you'll still have the right to have your case heard, but you won't have the right to stay in the home until your county court date. So after you file your appeal, you your hearing will eventually be scheduled in county court, you will get a whole new trial in county court, where the original decision and the evidence that was presented and everything from the court date of the justice of the peace in that case doesn't matter and doesn't affect the case anymore. If you lose in county court and you want to appeal, you should be aware that those appeals are very difficult and they do require an attorney. And so you just, if you lose in county court and you want to appeal, just make sure that you consult with an attorney immediately. It's very, very difficult to do on your own without an attorney. So the county court, after that hearing, they could potentially issue a writ of possession, the 24-hour notice again. It could be before 10 days are up sometimes, even though they should really wait 10 days. Sometimes they might issue it before then. So after your county court date, you just need to be prepared to move within 24 hours of when you receive that 24-hour notice, the writ of possession. So now I'm going to show you the appeal form that we've been talking about that has the appeal and the statement of inability to pay the court costs and the written answer is just automatically included towards the top. The first thing you want to do when you start filling out this appeal form is just get the lawsuit that you received or the court judgment that you got at the hearing, and you'll want to kind of track that towards the top of this appeal form, because you can insert, you'll see the cause number in the names, and I'll talk about that in a moment, but the first thing you want to do is just get the lawsuit or the judgment as a reference to use when you're filling out the form. And after you do that, again, you can sometimes ask the justice of the peace for the form, but ours does include the answer. And if you want to find the form that we give people, it's available at our website, www.trala.org/housing-COVID-19. You can also just go to our website, trala.org, and you can navigate from there, and this form is made available for eviction appeals or a statement of inability to afford payment of court costs. So you can print it out as you can either print it out as a blank form and then fill it out just with a pen and pencil, or you can complete it on your computer and type it in and then print it out. Either way works, it's just your personal preference. The form is going to be, again, an answer, an appeal, and an affidavit that you cannot pay the court costs. You want to make sure that you do not lie on this form. The judge might not know who you live with or who pays your expenses, but the landlord probably does. So just do not lie. It's not a good idea. So the first part of this form at the very top is, it has just the information about the case. So at the top left, it says name of plaintiff / landlord. The plaintiff is the person who sued you, typically your landlord in this sort of case. The defendant is you. You're going to fill in the case number and the justice court where the hearing was held and the county where you live, the same information from the judgment of the lawsuit that you are looking at when you start filling this out. After that, you're going to go input some of your own personal information. So you can see the first thing is your full legal name. Then there's date of birth, there's your address. And for the address, this is, there's two options. One of them is your home, and then one of them is your mailing address. So if you prefer to receive your mail somewhere that's not your home, just make sure that you write the mailing address into the box as it directs you to. Beneath that, you add your phone number and your email address if you use one. So let's go to the second section. This is going to be your household information and really your dependents. And so you do not always have to list everybody that you live with. This is going to be people in your household who depend on you financially. So some examples are your child or your partner, somebody who depends on you financially, not just somebody who you live with, but you don't share bills, you don't have any financial relationship. So again, it's just going to be dependents, people like your child, your partner, and in the form you can see that you just write the name of that person and their age and their relationship to you. So the third section asks about whether you applied for legal assistance with legal aid. So if you have a legal aid attorney, then you will check the first box. If you requested legal assistance from legal aid but you were denied, then you check the second box. And if you do apply with legal aid, then we can give you these certificates and documents that it's referencing. But basically for the first box, it's if you are being represented by a legal aid attorney. Again, for the second one, it's you applied with legal aid, but we just couldn't take the case. And then the third box is you didn't apply for representation or for legal aid. So this fourth part asks what type of government benefits you receive. If you don't receive any government benefits based on your need, then you just check this first box at the top right under the 4. If you do receive public benefits, then you check the second box and you're going to indicate which benefits you receive. So at the top left, just under that second box, the first public benefit you can see is food stamps or SNAP. Then there's TANF, LIS, LIS, and Medicare, WICI. If you live in public housing, there's Section 8, community care, low-income energy assistance, SSI, needs-based VA pension. There's a number of specific benefits listed, CHIP. So you just want to go through all of these, and any of them that you do receive, you make sure that you check the box. And then at the very bottom of this fourth section, there's an other option, and then you can just write in any other needs-based public benefits that you received that aren't listed here, just to clarify. On this fifth section, it's going to be about your monthly income and just the sources of your monthly income. So the first question is about how much you receive every month. You're going to write your job title and your employer who you work for. If your income changes, you can just write that in the available space in this section, a little bit beneath the wages. Like if you were just laid off, for example, you would want to write that down. It's okay to use the space that's available in the form to just give more information and clarify what you're writing, especially if your income has changed. If you list your gross income, then you can write gross on the side. If you list your take-home income, then you can write net on the side. Anything that gives the court information about how exactly you're reporting your income. So the second question of this section about the monthly income is about how much you receive in unemployment and how long have you been unemployed. So there's just there's the monthly amount, and then you just want to put the date that you became unemployed. The third question is about how much you receive in government benefits, for example, how much you receive in SNAP or SSI. The fourth question is how much do you get from other people in your home. So again, that's not going to be everybody that you live with necessarily. It's just going to be your dependents, people who or people who contribute to your household. If you're not related financially, if they're not your dependent, if you're not really part of the same household, then you don't have to include it here. The fifth question here is about how much you receive from other sources. It shows retirement, tips and bonuses, disability, workers' compensation, Social Security, military housing, dividends, interest and royalties, and child or spousal support. And also if you receive income from your spouse or from some other member of your household or dependent, like we talked about earlier. And then under that one, there's just an option for if there's any other sources of income. Just try to be as honest as you can, and you can just explain what the income is. Anything again that tells the court, gives the court information about your finances. The sixth section is about the value of your property. The first one is your bank accounts. So it's going to be typically how much is in your account, or just the value of the account and any other financial assets. The second one is vehicles. So you would list the make and the year, model, and the just estimated value of the vehicle. The third is any other property. So that'll be jewelry, land, a house other than where you live, or other valuable assets, other valuable property. So this seventh section is just your monthly expenses. It's at the bottom right of the second page, and you can see it just goes through all of your possible monthly expenses. So it has your rent and house payments and maintenance. It has your food and household supplies, utilities, gas, electricity, telephone. It has your clothing and laundry, medical and dental expenses, any type of insurance like life, auto, health, your school and child care, transportation, auto repair, gas, child support, spousal support, or if your wages are withheld by court order, debt payments, and there's a list at the very bottom for other sorts of expenses. If they're monthly expenses that you have, you should include them so that the court's aware of them when they're looking at this form. So this on the top of the third page, this part 8, it gives you a chance to explain or give information about your financial information if it didn't appear in other parts of the form. It's always good to give as much information about as you can about your debts, because that'll show why you can't afford the court costs. And again, it's just anything else you can think of that you would consider your debts that would help explain your financial situation that's not addressed further above in the form. So part 9 it's called a declaration. You are declaring under penalty of perjury that what you've said in the form is true and correct. You can see there are 2 boxes listed here. So in the first box, you're saying you cannot afford to pay the court costs, the court expenses. And in the second box, you're saying you cannot afford the appeal bond for the cash deposit. So as long as you've properly listed your income and you've been as honest as possible, and you've explained all of your debts as best you can, at this point you're going to just put in your name again and your date of birth and then your address. You do have to sign it at the very bottom. You say the date you signed it and the county that you signed it in. To actually file it after you fill it out, typically you would take it in person to the justice of the peace, but if you can't go in person because of the COVID-19 pandemic, then you can call the court and ask how to file it without putting yourself at risk. You can ask if you can email or fax it, or just what options are available to try to file it without going in person because of the current risk. Just make sure you also send a copy of the appeal to the landlord by certified mail if possible, or if not, by regular mail. The most important thing to file is to file the appeal in court, but on that same day, just send a copy of the appeal to the landlord as well. So I think that's the end of this video. I hope it's helpful as you try to understand your rights in the eviction and eviction appeal process.